This is the podcast of the NOVA Center on Business, Human Rights, and the Environment. Welcome.
Hello, everyone. Welcome to the new episode of the NOVA Center on Business, Human Rights, and the Environment podcast. This episode will be held in partnership with PLMJ law firm. I am Inês Crispim. I am an associate researcher at the NOVA Center on Business, Human Rights, and the Environment, and a lawyer at PLMJ. Today, we are speaking about the model contract clauses to protect human rights in global supply chains. Corporations are increasingly being expected to adopt responsible business conduct and to protect human rights in global supply chains. In particular, through the adoption of due diligence processes that enables them to address human rights adverse impacts, not only deriving from their activities, but also throughout global supply chains. This is a global movement that started as a voluntary conduct fostered by investors and consumers' pressure. However, the evolution of market practices, the approval of legislation on human rights due diligence in many European Union countries, and the publication of the proposal for the Directive on Corporate Sustainability Due Diligence has showed us that protecting human rights in value chains will progressively cease to be merely optional. This will deeply affect business relationships and consequently contracts drafting. In the United States of America, the American Bar Association has developed model contract clauses to protect human rights in global supply chains, the so-called MCCs. In Europe, a group of experts is also working in developing model contract clauses. Today, I am delighted to be interviewing Professor Sarah Dadush and Professor Claire Bright.
Hello.
Hi. Hi, welcome.
Thank you.
Sarah Dadush is a professor at Rutgers Law School. She also directs the Business and Human Rights Law program. She is co-leader of the American Bar Association Business Law Section Working Group that has developed the model contract clauses to protect human rights in global supply chains. Professor Claire Bright is an associate professor in private law in Nova School of Law. She is also the founder and director of the NOVA Center on Business, Human Rights, and the Environment. She's a part of the expert group that is working on the development of the European model contract clauses.
Thank you so much, Inês.
Professor Sarah, can you tell us more about the MCCs and why they were developed?
Sure. So the model contract clauses, these MCCs, were developed under the auspices, as you said, of the American Bar Association through the business law section of the American Bar Association. And they consist of 33 model contract clauses that companies can take and include or integrate into their international supply agreements. So their contracts with manufacturers or agricultural production entities anywhere in the world for the purpose of improving the human rights performance of those contracts. And so by extension, the idea is that if you improve the human rights performance of the contracts, then you can improve the human rights performance of the supply chains. So there are 33 of them. They're drafted to be pan-industry, so they're not sector-specific. And they're also drafted to be modular, so companies can take them, and the idea is that they would edit and adapt them to suit their own needs and risk exposure and appetite, frankly, for upgrading their human rights due diligence efforts.
Very interesting. And why are traditional approaches to contracting inadequate when it comes to protecting human rights, and in particular of workers?
Yeah, so part of the reason why we developed the model contract clauses is because the way that we as lawyers traditionally tend to think about contracts, we don't think about, let's say, a defective product as being defective because it was made in a way that violated human rights or that was not aligned with standards contained in the UNGPs or the OECD guidance or things like this. We tend to think about, non-conformity or product defect as being something that is about like the thing doesn't work. We don't think about how it was made. Was it made by child labor? Was it made in a working environment where people didn't have access to fire safety doors or good working conditions, or were they paid appropriately in time? Were they paid for overtime? All these kinds of things we don't consider to be part of product conformity or product defect. So part of what we were doing with the MCCs is to try and give lawyers a toolkit for integrating human rights into their contracts, and to have a different notion of what is a defective product. Not just something that doesn't work, but something that was made in a way that wasn't in alignment with human rights. And traditional contracts aren't terribly good at doing that, in part because lawyers don't necessarily know how to do it, but also because oftentimes the reflex, if you have a human rights risk or any kind of risk in your contract, the reflex is going to be to try and shift that risk onto your counterpart, right? Sort of make it so that you have less on your side of the contractual balance sheet and your counterpart has more. And so the traditional approach to contracting around contracting for human rights is to say supplier is solely responsible for upholding human rights in this contract. And if there is an issue, we, buyer, have the right to terminate immediately, and there will be stiff penalties, et cetera, et cetera. This doesn't work, and it doesn't work for a few reasons. The first reason is that this kind of representation, it usually takes the form of a representation and a warranty, right, by the supplier that everything is perfect in the supply chain. No child labor, no bad working conditions, absolutely zero concern around payment of wages, adequate compensation, et cetera, et cetera. These representations are impossible to be true. It's impossible to verify. And even if it is true at the time the contract is signed, it's impossible to promise that it will remain true throughout the life of the contract. So really, when buyers ask suppliers to make these kinds of promises, and everybody recognizes this, they're asking the supplier to make a fictitious, empty, imaginary promise. And this doesn't really help anybody. It doesn't help the buyer actually to protect themselves against risk associated with human rights. It also doesn't help workers, because when you create the situation of unilateral responsibility, there are all kinds of incentives then for the supplier to hide any issues. If the consequence of an adverse impact being discovered is that your contract is going to be canceled, you're going to lose access to this buyer and possibly other buyers as a result, your incentives are going to be such that you're going to try and just push bad things deeper into the shadows of the supply chain. So it's not good for workers. And also it's not good for just reputational risk as well for the firm and for effectiveness of the buyer's contracting strategy, right? If the idea of having a representation or warranty is that you've somehow reduced human rights risk, that hope is not met through this strategy. You need a different approach to achieve effective human rights risk reduction.
And how do the MCCs adopt that different approach?
So the MCCs are very deeply rooted in the UN Guiding Principles on Business and Human Rights and in the OECD guidance. So we basically are we've made an attempt to kind of Google translate the UNGPs into binding contractual obligations. And that translation is not perfect, like Google Translate. It is an imperfect effort, but it is a first effort. And one of the key features of this effort is that the MCCs seek to embody the shared responsibility principles that are enshrined in the UNGPs. The UNGPs say not just the buyer, not just supplier, but all corporations have an obligation, a responsibility to avoid causing or contributing to adverse human rights impacts. All corporations, doesn't matter how big you are, doesn't matter where you are in the supply chain. The content of that obligation may differ, but the idea is everybody shares responsibility. And you can't just offload it. So that's like the key starting point, I would say, of the MCCs, in particular the MCCs 2.0, is to take this shared responsibility principle and translate it into the contract. So what we do is, instead of having the unilateral representation and warranty by the supplier, we say both buyer and supplier undertake to engage in ongoing human rights due diligence throughout the life of the contract. And that obligation to carry out human rights due diligence also cascades throughout the supply chain, so that you are really sharing responsibility across all the different actors that are touching this contract, and in order to cover all the workers that are stakeholders in this contract, right, or impacted by this contract. So that's really the big sort of paradigmatic shift that the MCCs bring, is this notion of shared responsibility, switching from a frame of unilateral representations and warranties to a shared obligation to carry out a human rights due diligence. A second key distinction between MCC-aligned contracts and traditional contracts is that we include a section on buyer responsibility to engage in responsible purchasing practices. A lot of traditional contracts don't consider how the buyer's behavior can impact on human rights or on suppliers' ability to uphold the buyer's human rights standards. So things like pricing. You have to have responsible pricing. If you have pricing that you know to be below the cost of production, the odds are that is likely to increase a risk of an adverse human rights impact. We also say that buyers should provide assistance, reasonable assistance to the supplier in meeting the buyer's own human rights standards, and that assistance can be financial or it can be technical. We also say that if buyer wants to make changes to their orders, they should do it in a responsible way, considering, what is the human rights implication of tripling my order without giving additional production time to the supplier or increased per unit price to cover the cost of overtime. Another example of responsible purchasing practices relates to exit. So with COVID, we saw a lot of companies abandon their suppliers, cancel their contracts, which had enormous implications for the human rights of the workers who lost their jobs. Enormous, like the economic equivalent of a Rana Plaza, but times on people's livelihoods. Something like 60 million people were affected by these contract cancellations. So you have to exit responsibly, consider the adverse human rights impact associated with your decision to terminate, and make an effort, as HRDD or the UNGPs ask you to mitigate those impacts. A last distinction between traditional contracts and MCC-aligned contracts pertains to remedies. So traditional contract remedies would flow from the breaching party to the non-breaching party. And that might make sense where you're dealing with a commercial breach of contract. But where you're dealing with a social breach of contract, you need a different kind of remedy structure that channels remediation to the victims, right? Because the buyer hasn't been harmed. I mean, maybe they've been harmed commercially, but the harm that we're looking to address if we're contracting for human rights is the human rights harm, which means that remediation has to be channeled to the victim. So we say human rights remediation should take priority over traditional contract remedies. So these are our three shifts away from traditional contracts.
And those are big shifts, especially regarding the responsibilities of the buyer.
Yes.
It's a whole new type of contracting.
Yes, it's a revolution.
It is, undoubtedly. It's a revolution. And Professor Claire, I would really like to know your view about the MCCs in Europe. What do you think will be the role of the MCCs in European Union, if any?
Thank you for that question. I think it's really important question. What we saw in the study for the European Commission on due diligence requirements for the supply chain is that contractual clauses are one of the most utilized tools by companies to do their due diligence. So we had contractual clauses and audits amongst the top tools. Now, of course, that doesn't mean that they are free from concerns or free from criticisms. And Sarah was explaining earlier the risks, especially with traditional contracting, that you would have companies just trying to shift their responsibility onto their co-contractors. And so what we see is because companies are actually using it in practice, we might as well try to do it right. And so model contractual clauses can be a way to make sure that the shift of responsibility does not happen and that the contractual clauses are aligned with the UN guiding principle, with the OECD guidelines, etc. So that's an important point. When we look at the Draft Directive on Corporate Sustainability Due Diligence, we see that model contractual clauses are envisaged. There's a particular Article 12 that provides that in order to provide support for companies to facilitate their compliance with their due diligence obligations, the Commission shall adopt guidance about voluntary model contract clauses. So we see that it's something that has been thought about and that is already present in the Draft Directive. We also see in that draft directive a place for contractual clauses or contractual assurances, as they call it, in various parts of the draft directive, in particular in relation to the human rights due diligence expectations of companies. So in particular, for instance, in Article 7, which is on preventing potential adverse impacts, we see it mentioned at Article 7, paragraph 2.b, where it says basically companies should seek to obtain contractual assurances from a business partner with whom they have an established business relationship, that basically they will be also obeying certain standards and adopting a code of conduct to respect their standards as well in their own activities. And if necessary, it will also adopt a prevention action plan to make sure that they have incorporated and they're acting upon these promises. The Article 7 also contains an important addition in paragraph 4, which is about the need for companies to adopt and to accompany these contractual assurances by measures, appropriate measures to verify compliance. Now, these provisions, together with the provisions of Article 8, which are about bringing actual adverse impacts to an end, which also refer to contractual assurances and measures to verify compliance with these assurances, they have raised concern, and particularly on the part of civil society has been quite worried about the over-reliance of the Draft Directive on these contractual assurances and on audits, which we know from various studies now that by themselves are not sufficient for companies to carry out adequate due diligence. So the point I'd like to make here and to highlight is these are measures that are important as part of the sort of whole toolbox that companies have to do their due diligence, but they are not by themselves enough, and they will never be. So they have to be accompanied by something, by other measures. When I look at the text of the draft directives, what reassures me in relation to these concerns is that due diligence is really envisaged as a standard of conduct. And we see that through the use of these terms like appropriate, right? So it's measures that are appropriate in the circumstances. And that to me is in line with the understanding of due diligence as outlined in the UN Guiding Principles on Business and Human Rights, and basically means that it is not going to be enough for companies to simply have contractual clauses in their contract or simply carry out audits to say, okay, I've done this, I've done that, so hence I'm off the hook, I've done my due diligence. No, it's not enough. It has to be appropriate. And that's always going to be the evaluation of that appropriateness as, again, the standard of conduct. Was that sufficient from measures from a reasonable company that could be expected from that company in the circumstances of the case that will be evaluated? And I think that is really important to sort of bear that in mind when we look at these requirements of both contractual assurances and measures to verify compliance in the draft directive.
And how are the contractual assurances and the measures to verify compliance relevant, and what role do they play in relation to the civil liability, especially the provision in the draft directive?
Yes, so indeed we have Article 22 on civil liability, which provides that companies that fail to comply with their due diligence obligations should be liable for the damage that basically that failure to comply caused. And then there is, in paragraph 2, we see a due diligence defense whereby companies that have taken those contractual assurances, that have taken those measures, the appropriate measures to verify compliance, shall not be liable, and here I quote, for the damages caused by an adverse impact arising as a result of the activities of an indirect partner with whom they have an established business relationship. If I were just to look at that part of paragraph 2, that would worry me, because that sort of seems to imply there is a sort of automaticity. So basically, again, I'm doing that and therefore I'm exempt from liability. This would be problematic. This would be completely not aligned with the UN guiding principles on business and human rights that specifically say that even conducting human rights due diligence should not automatically mean that companies are exempt from liability. However, again, if we continue reading that paragraph, the next part I think is essential here, and it adds, unless it was unreasonable under the circumstances of the case to expect that the actions actually taken, which includes contractual clauses and actions regarding verifying compliance, would be adequate. And again, here we see this terminology, we see the terminology in terms of reasonableness, in terms of adequacy, which again point to that idea of the standard of care, the standard of expected behavior, and the fact that no, it's not simply because a company would have adopted contractual clauses, would have carried out X amount of audits, that they would be exempt from liability. Again, what is going to be assessed by the judge will be whether these measures were adequate in the circumstances of the case. And again, maybe the content as well of these clauses. And I think that links to also what Sarah was saying as to, how are these clauses drafted as well? I think that would be a really important point in considerations of liability.
Yeah, so if I can add to that a little bit, I mean, on the content of the clauses point, under certain circumstances, it should be unreasonable for a buyer to rely on a unilateral representation and warranty by a supplier, right? They have to do more homework than simply contractually assign responsibility. It's not entirely clear, also from, I think both Claire and I agree, it's not entirely clear from the draft EU directive what would constitute an adequate contractual assurance. So something is going to need to be worked out around that. Our feeling, as I speak for the US MCC group, is that the right kind of contractual assurances could actually go a long way toward achieving effective human rights due diligence, or to enable the carrying out of effective human rights due diligence. And what we mean when we say the right kind of contractual assurances are those that are rooted in the UNGPs and that contractualize this shared responsibility approach to upholding human rights and avoiding causing or contributing, including through your purchasing practices, to adverse human rights impacts. And we don't think this is like a massive, yes, it's a revolution in some senses, but also it is, we don't go farther in the MCCs than the UNGPs. We don't go farther than the OECD guidance. So in that sense, it is not so revolutionary. And it is really a practical tool for making these principles that so many companies say they subscribe to really embedded into the legal life of the company. And the legal life of the company is lived in part through its contracts. So it is revolutionary in some sense, but not if you think about it in terms of effectiveness, right? A lot of companies say they subscribe to the UNGPs. A lot of companies have human rights policies or ESG objectives that they wish to pursue. And this has nothing to do with, deception or insincerity or greenwashing, but simply there often tends to be what we can think of as a coherence gap between what the companies say they want to do socially, environmentally, and what their contracts tell them to do. There is a mismatch. And so the MCCs are, and the right kinds of contractual assurances that we hope to see emerge from the European Commission's process to develop model contractual clauses that would satisfy the requirements of the directive, the point of them should be to make these policies effective, do more than just, sit and look pretty on a website, but actually bridge the coherence gap. Allow, contracts can be drafted in such a way that they can really be powerful allies for companies looking to effectively uphold human rights in supply chains, achieve environmental objectives as well. And we sort of feel that, you can't really do good human rights due diligence and you can't really do good ESG without having good contracts. And the MCCs are an example, a toolkit that companies can use to inspire themselves to bridge the coherence gap.
Thank you very much for these very interesting insights. Thank you, Professor Sarah. Thank you, Professor Claire.
Thank you, Inês.
Thank you so much. It's really lovely to have this discussion.
We've come to an end to one more episode of the podcast on the NOVA Center on Business, Human Rights in the Environment. Please subscribe to our podcast, both in YouTube and in Spotify. And thank you.
Thank you so much. Bye-bye.
Thank you.